Welcome to today's edition of Florida Appeals Journal, which we're now on podcast. I'm Jennifer Carroll, and today I'm going to talk about something actually pretty basic, some of the nuts and bolts of the appeal process, which I think is very relevant, of course, to practitioners as well as individuals who are just getting started in the litigation process and certainly in the appeal process. So I'm going to do my best to take some of the mystery out of filing a notice of appeal, knowing when to appeal, and again, some of the procedural nuts and bolts. So hopefully I can make the process a lot easier for litigants and individuals just getting started with the appeals process. So the first question we need to look at, we're going to look at some basics. You get an order, you're not happy. You got to ask yourself, what kind of order do I have in front of me? You've got some determinations to make. First, do you have a non-final order or do you have a final order? Finality, general rule of thumb, is there still judicial labor that has to be completed in the case? Again, that's just a very basic rule of thumb. So if it's a non-final, you haven't reached the jury verdict yet, for example, and there are other considerations, but you have a non-final. Most non-finals are not appealable, all right, to the appellate court. There are certain appealable non-final orders that the rules of procedure recognize and that Florida law recognizes. You will go to Rule 9.130 of Florida Rules of Appellate Procedure. And in that rule, it lays out the specific appealable non-final orders. And for example, you have an order that concerns venue. You have an order that concerns personal jurisdiction, that it has to determine jurisdiction of the person. So look at the exact language of the rule. And the right to immediate possession of property. That's an appealable non-final order. The right to immediate monetary relief in family law matters. The entitlement of a party to arbitration. These are a few of the more common examples of an appealable non-final order. So you would go to that rule, and there are certain timelines. Of course, the 30-day timeline still applies. So you have 30 days to appeal that. But you're not going to have the clerk prepare the record on appeal for you, all right? You're going to do an appendix. So you got the 30 days and then 15 days within which to file your brief, and you will attach an appendix, and you need to follow the rules in the appellate rules and your local administrative rules of the administrative orders in your particular district court that you're appealing to for specific procedural and technical rules governing preparation of the appendix. And you can always move for extensions, but again, it's really not the same. You won't get the same treatment as you do with final appeals on that. But the key is you do have a different timeline on when the brief is due, and there's no record transmitted. Okay. Now, I want you to distinguish the non-final appeal, so an appeal from a non-final order, from an extraordinary writ. You can have non-final orders that don't fall under the non-final appeal rule, and normally you would have to wait till the end of the case. But there are some non-finals that you can invoke the original jurisdiction of the appellate court. And by the way, that's 9.100 of the Florida Rules of Appellate Procedure. But remember, it's the original jurisdiction of the appellate court. So people use loose language. It's an appeal. It's an appeal. Well, it's in the appellate court, but you're invoking the original jurisdiction. So that does become relevant on many other issues down the road. But if it's the type of order that the court will entertain on extraordinary writ, then you would follow Rule 9.100. And we've actually done some discussions on those, and I think you'll see them on I think YouTube, the website. But we have a series of videos on the writs. But the most common is the writ of certiorari, very popular petition. And you still on that one, you still have your 30 days. You want to file your petition, not a notice. So you're going to have your brief done. And there's a a format you have to adhere to on that. And again, records, it's original jurisdiction. You're going to put an appendix together for that. And the petition for writ, your standard is, is there a departure from essential requirements of law? Is this something that just can't be remedied by a normal final appeal? And you have irreparable harm included in that. So you've got to look at what the case law says and gives examples of what type of orders would be subject to a petition for cert. And of course, the most common is really discovery matters. A very, very common. You have a cat out of the bag situation. So if you follow the trial judge's order, you're going to release these very important trade secret materials that's going to interfere with competition. It's proprietary for a company, for example. You're going to want to do a petition for writ of certiorari, and that's commonly recognized as being appropriate subject matter for the petition for cert. So that's one example. And you'll look at, we've talked about writ of prohibition, mandamus, quo warranto. So they all have different rules and different deadlines. But just remember, they are writs, mechanisms you're using to invoke original jurisdiction. So they're really different from the appealable non-final orders under 9.130. So you need to consider that when you're looking at your order and determining, well, what kind of order is this? Because that's going to determine what my remedy is. If I do, I have to do an extraordinary writ. Is this a non-final order that I can appeal under the rules? Then you look at 9.110. Well, maybe you have a final order. Okay, I guess that's pretty common. You get your final order. Always, nothing really is as what it appears, right? So is it truly final? Again, you have to look at, is there any more judicial labor that has to be conducted? And I'm sure most of you know, you get a final order. It could be from a non-jury, or you get a jury, you get a verdict, and you get a judgment on that. But the rules of civil procedure allow for motions for rehearing, for example, against that final order. And if it's an authorized and timely motion for rehearing from a true final order, that will toll the time for taking the appeal. So you make sure it's timely. The rules dictate the timeline for you to do your motion for rehearing. And that the time for starting the 30 days for appealing will take place once an order is issued on that. So you want to be careful. That's really one of the typical landmines that gets messed up a lot. So you want to be careful, because if you miss that 30-day, the timeline for filing a proper notice of appeal, there's no going back. That is jurisdictional, and that is probably the biggest mistake that an attorney can make, is to miss that deadline. So when in doubt, file the notice. Always take a very conservative approach, and you always want to act in abundance of caution on that. So just keep that in mind. And I believe it's 9.020H also gives you examples of motions, also tolling rendition. And I just want to say one small thing about rendition. It is rendition of an order that starts the timeline for filing the notice of appeal. And that's the filing of a signed order with the clerk of court. Sometimes that could become a lifesaver for you. So it's always rendition that triggers the 30 days. Again, 9.020H will address that for you. And then just keep in mind, because this is a very common issue that arises when you're dealing with attorney's fees. You can have an order, and whether it's in family law or really any other kind of civil case, and you've got your judgment, but let's say the trial judge determines entitlement to one party's entitlement to attorney's fees, but they reserve jurisdiction on the amount. Okay, you're still going to want to appeal that order on the subject matter, the main subject matter for the main part of the judgment. You won't be able to appeal the entitlement portion of it until the amount is determined. So what you'll do in that case is you'll get the amount on a subsequent order, and then you will appeal that, and you'll want to appeal that in consolidated ideally if the timing works, but just keep that in mind. And that's one of the little nuances you want to be aware of, and there are many more, and we'll address that on really in the future under other topics. So you're going to take your judgment. Let's say you got a final judgment. So what are the nuts and bolts? What do I do with it? Well, of course, you attach it to your notice of appeal, right? Your certified copy, attach it to the notice of appeal. That notice gets filed in the trial court, and then the trial court is going to transmit to the appellate court. So the trial court is going to docket it. They send it over to the appellate court. And again, can't overemphasize that 30-day rule. You'll get an acknowledgement by the court, and you want to pay your filing fees, the $300, and then I think it's $100 in filing fees, and one goes with the trial court, and the other is $300 in the appellate court. 10 days after filing the notice, you have directions to the clerk, and you're telling the clerk of the trial court what you want included. If you go under the Florida Rules of Appellate Procedure, it's going to tell you, I believe 9.200 is going to explain the record, and Section 8, the contents. But basically, if you don't do anything, the clerk will include just about everything, but they exclude your notices of hearing, subpoenas, discovery matters, and that can be important. That's important to know, because if the issue you have on appeal is going to involve some procedural matter involving discovery when something was noticed for hearing, you will want to notify the clerk, give them directions saying, okay, this is specifically what I want. And you can have a gigantic record and you're really only appealing certain issues. So you want to make sure your record is tailored to that, if at all possible. And they charge a prep for record on appeal. So there's a fee for that. So you want to tell your client about that. And you'll also do designations to court reporter, and then form that you basically assuring the court that you've made arrangements with the court reporter to have the hearings transcribed, to have the trial transcribed, and then that gets filed and that gets made part of the record on appeal. And just bear in mind, sometimes you may miss, there may be a certain hearing, or there may be certain documents that the clerk left out, inadvertently. Maybe you left out inadvertently, and you get into the brief and you say, oh, you know what? I thought this was here, but it's not. You can move to supplement, and the appellate courts are really good on that. I mean, every district's a little bit different on how strict they're going to be, what they're going to require, but they'll do your motion to supplement. And the appellate courts want to address cases on the merits, so they don't want to play procedural games and gotchas and that kind of thing. So they want the merits. So if it is relevant to the issues, again, you want to do it, as soon as you possibly can, and as soon as you find out, you'll do the motion to supplement. And the clerk will supplement once they get an order from the appellate court. They'll supplement your record on appeal. All right. Some timelines you want to be aware of. Again, always look at the rules. Make a chart. We may put one up on the site to help you on that. But within 50 days of filing the notice of appeal, okay, you have the clerk of the trial court will prepare the index to the record on appeal. Then the clerk prepares that and serves the index to all parties. And then within 110 days of the notice, the clerk will electronically transmit the record on appeal to the appellate court. The briefs are served within 70 days of the notice of appeal. And oftentimes, you can seek an extension for filing that brief. The appellate courts have their administrative orders on that, but in the fourth, up to 90 days, and you can get an agreement and just do an agreed notice. Otherwise, beyond that, you'll do a motion, and you always want to show good cause, of course, for getting the extension. But again, the state appellate courts are pretty good on that. And really, I'm amazed. The federal courts have actually gotten more lenient than years ago. Years ago, couldn't get an extension, you'd be in a lot of trouble. They really have gotten more lenient, not as lenient as the state courts, mind you, but That's always a good thing. You want a little bit of leniency on those type of issues. Now, you need to realize that just because you do a notice of appeal, you don't get an automatic stay. All right, it's no automatic stay. So if you need to stay the execution or implementation of your order, you're going to want to file in the trial court a motion to stay. And you're going to have to show your appeal has merit. There's no prejudice to the other side. You got to, you think you're going to win on the appeal, which really is always kind of tough because you're trying to tell the trial judge, that you just issued this order, but I think you're wrong. I think I'm going to win the appeal. I think that's a tough situation. So, but that's the rule. So you have to do your motion for stay, and then under the appellate rules, you can seek review of that stay order. So you'll have your notice of appeal out there. So you have an appellate case number, an appeal opened, and so that motion to review the stay order will be under that umbrella. So it's not a separate appeal or a separate filing fee. So keep that in mind. And I think it is important, and I want to point you to the rule 9.310, Florida Rules of Appellate Procedure. That's a governed stay pending review. And a couple things. The trial court will have jurisdiction to issue appropriate conditions for a stay. May require a bond, may require certain actions. But do remember, if it is a pure money judgment, just a judgment or order just for the payment of money, you can file a supersedes bond and get an automatic stay. And that's going to be under B1, governing money judgments. And that you can do that without even having to go to the trial judge. And the other thing to remember is, always like this, the all writs provision. If you look at the comments to Rule 9.310, let me just quote, although the normal and preferred procedure is for the parties to seek the stay in the lower court, this rule is not intended to limit the constitutional power of the court to issue stay orders after its jurisdiction has been invoked. So arguably, the appellate court has jurisdiction to issue a stay, but 9 times out of 10, they want you to go to the trial court first. But they do have authority. If you go up there on a motion for review, you can do a separate motion for a stay, a temporary stay. They do have jurisdiction to issue some orders they think are warranted under the circumstances of the case. So just when you read these rules, read the comments too. I think that they're very important. But general rule is always go to the trial judge and try to get that stay. So the administrative orders, there are administrative orders, and I think you go on the website, you'll find that. But I know, for example, in the 4th District, agreed notice of extension of time is accepted up to 90 days for an initial or answer brief and 15 days for a reply brief. Now, it doesn't apply to appeals from adoption, dependency, termination of parental rights, non-final orders, or any expedited or emergency appeal. So that's administrative order number 2018-1. And administrative order of the 4th talks about your submission of electronic filings to the court through the statewide portal. So you want to be aware of that. And there's an exception to that. If there is a paper filing is authorized, then you'd be able to do that. And then on appendices, remember there are special rules regarding the electronic filing of appendices, and that's Rule 9.220. And it talks about the contents of the form, again, electronic format, and you always want to make it so it's easy for the judges, appellate judges who do an awful lot of reading. You want everything to be bookmarked so they can just, hit a button and go directly to the issue that you're talking about in your brief. Everything has now gone to, as we all know, electronic review, and they're reviewing these files electronically. So now everybody's got to be up with the technology that makes it very easy for these judges to review your brief and review the record. So that's I'm getting into too much detail, more than I wanted to, but those are just some of the, I think, the fundamental nuts and bolts that you'll need to know when you are considering an appeal. If you have any questions, as always, feel free to contact us. Thank you again for joining us on the Florida Appeals Journal, this edition. We will be having future editions, and if there are issues that you do want to have heard on one of these entries, or even on the podcast, which we're running at the same time, by all means, let us know. Thank you again for your time. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.